All right, I think we're going to go ahead and get started. Welcome to everybody who's joined us. Thanks so much for taking time on a Wednesday morning or afternoon, depending on where you are. My name is Allison Korn. I'm the Assistant Dean for Experiential Education here at UCLA School of Law, and I'd like to formally welcome you all to our second session in our Teaching Justice webinar series for the 2020-2021 school year. Today, the topic is Teaching Human Rights Lawyering Through the Lens of Critical Theory, featuring Denisse Córdova Montes and Carrie Bettinger-López from University of Miami School of Law.
And I'm Layla Halas. I'm the Director of Experiential Learning at Tulane Law School. And I'm also the co-chair of CLEA's Best Practices in Pedagogy Committee. And today's talk and the whole series is part of a project coming from this committee. Teaching Justice webinar series is a project which really looks at the current resistance movement and thinks about the wisdom that is coming out of there, innovative teaching examples and thinking about the intersections with a variety of different lenses, such as human rights, critical theory, racial justice, economic justice, criminal justice. We have a really great lineup for the rest of the year. We have a couple presentations coming up this spring, and we ask you to keep checking back. And also on our website, on the CLEA website, the past recorded webinars from the past couple of years are also there. So we encourage you to visit that as well.
We do want to let you know, you should have gotten a notification already that this session will be recorded, and it also will be made available on the CLEA website shortly after we conclude. We'll circulate that information and link later on through the listservs and through the website. And the presenters today do encourage interaction using the chat function. So please, if you'd like to already, you're welcome to use the chat function right now to introduce yourself, maybe talk about what you are teaching. And if you bring any burning questions to the session today, I do want to note and set expectations that the presenters do plan on using breakout rooms for a brief period during this session today. So we encourage everyone to participate in these small groups. And that's even true if you are just participating by phone or aren't able to use your video function. We welcome your participation in those groups regardless. We do ask everyone to mute their microphones for the session, but you are welcome to keep your video on or off, depending on how comfortable you are. And I think that's it. And I will kick it over to Carrie and Denisse. And thanks again to our presenters and to all of you for joining us today.
Hi, I'm Carrie Bettinger-López. It's great to be here. Thanks so much to Allison and Layla for coordinating this series. I've really enjoyed, particularly at this difficult moment in all of our lives, enjoyed having this moment to both convene as a clinical community and to think critically and to really, grapple with the complexities of our times and what it means for our teaching practice as clinicians. So it's great to be here. I'm especially interested that this is such a multidisciplinary group of clinicians on this call because that, for me as a human rights clinician, enriches my practice and my teaching deeply. And as Allison said, we really want to encourage everybody to participate. Feel free to jump in, whether raising your virtual hand or using the chat function. Because the ideas we're talking about, the work that we're presenting really stands on the shoulders of a lot of giants in our own field. And some of them are here today. I see Louise Trubeck and I'll be citing to some of her work in my comments, in my presentation. She and so many others have really laid the foundation for me as a clinician to think critically about my work and then to really expand a lot of the critiques of lawyering that have taken place in the domestic context and bring those and extrapolate them into the global context where a lot of my work is located. And I'm also just so pleased to have the opportunity to present this webinar with my colleague Denisse Córdova Montes. And Denisse is co-teaches the Human Rights Clinic with me at University of Miami Law School. along with Tamar Ezer, who is, the three of us make up the team that teach the Human Rights Clinic. And I'm just so grateful and fortunate to have them as my colleagues. So, okay, we are going to get started. And what we'll be doing, I'd say this kind of takes place in 3 phases. The first phase is I'm going to give a little bit of a background on kind of critical legal theory and its application in the human rights context. And that's building largely on an article that I co-authored with several clinicians, both poverty law clinicians and human rights clinicians, about a decade ago. And so I'll be kind of laying out some of the basics of how critical legal theory applies in the context of human rights clinics, also drawing upon the context of poverty law clinics and other law clinics, and thinking about the application of critical legal theory to those clinics, and then lawyering generally. Section 2, Denisse will dive into a particular case study, presenting the ways in which we have applied some of these concepts and frames through work that Denisse has done, really groundbreaking work on the right to food that she has done in partnership with colleagues around the world. And in this particular case, she'll be giving you a case study about work that she's done in Latin America. And it's really so admirable, and I've learned so much through Denisse's work. So I hope that you'll enjoy kind of that case study. And then third, as Allison mentioned, we're going to give you a simulation that we use in the clinic. And we're really looking both for you to engage with the simulation as teachers and think about how you might apply it in your own classrooms. But we're also looking for your own critique, right? We can't talk about critical legal theory without inviting critiques of our own work. And looking back on it, it's a simulation that I developed with some colleagues over a decade ago. And looking back on it, I saw places that I think it really could use some updating. And so we would welcome your thoughts on how it could be updated, adapted, modified, changed, whether it's for a particular human rights or a particular type of clinic, or whether it's just grappling with how critical approaches might prompt further adaptation of this simulation or others. Okay, so with that, I'll just pause to see if Denisse wants to jump in or anybody else wanted to say anything.
Thank you so much, Allison, Leila, and everyone for having us today. I'm really thrilled to be sharing this space with you, and I look forward to discussing what we present.
Okay, so I'm going to share my screen now. Hopefully this will work. Okay, do you all see this PowerPoint? It says teaching human rights lawyering through the lens of critical theory. Yes? Good. Okay, great. All right. Always a tech challenge. Okay, let me just put the Zoom at the top of my screen so I can follow along. Okay, and feel free to wave. I probably can't see the chat function, so if there's any issues, feel free to just interrupt me. Okay, and let me just do a time check. All right, so okay, so as I said, the beginning of this presentation, a lot of the frame that I will be drawing upon is from an article that I co-authored with several of our amazing clinical colleagues. I'm sure many of you know them: Deborah Weissman, Davida Finger, Sarah Paletti, Jonelle Newman, and Mitali Jain. And we wrote this article, Redefining Human Rights Lawyering Through the Lens of Critical Theory, Lessons for Pedagogy and Practice. We wrote this in 2009, and it was really a AALS clinicians meeting conference that brought us together. We came, as I said, from the perspective of people who taught human rights clinics and people who taught poverty law clinics to kind of take on what critical legal theory means for human rights clinics. So we began with thinking about a trope which the professor has called savages, victims, and saviors. The idea that in international human rights lawyering, there are savages, there are wrongdoers that need to be brought to justice. There are victims who are helpless victims who need to be saved. And then there are saviors who are oftentimes represented by the valiant human rights lawyers or the human rights institutions that we use to redeem rights. And Makamatua really dissected this narrative and poked many holes in it, drawing upon other work that has been done. But he wrote this path-breaking article that really just showed how much that narrative reinforces imperialist and colonial narratives, reinforces the superiority of people in power, in this case lawyers, and essentializes victims, others, those who are marginalized, and recreates many of the same problems that we're supposedly trying to remedy. And I just want to read to you, this is from our kind of the beginning of the article. We say that critiques of international human rights lawyering point to imperialist narratives and victim essentializing, often perpetuated by human rights lawyering. And while these critiques may apply with equal force to the international and domestic human rights arenas, they're most often leveraged against advocacy directed outside of the United States, and work that is project-based or norm-driven, or that involves direct representation of individuals that's characterized by law and advocates alike as vulnerable victims. And then we went on to write about how human rights clinical law professors often struggle alongside our students to develop lawyering strategies that are responsive to these critiques, but yet still effective in achieving the goals of clients, whether those clients are individuals, groups, or organizations. And we write that although these ethical, strategic, and pedagogic challenges may be relatively novel for human rights clinicians, they're familiar terrain for many poverty law clinicians who have long struggled with similar challenges in the context of direct representation of poor marginalized clients and engagement in law reform and impact advocacy efforts. And so we talk about how clinicians in other areas of social justice lawyering, particularly those working in the poverty law arena, have developed a rich body of scholarship in this area that's been influenced by the corpus of critical legal and social theory. And nevertheless, we say, these challenges remain for poverty law clinicians as well. And so that was kind of our goal in this article. And from that, we kind of, okay, there we go. We start out asking the question, kind of laying out the groundwork for what critical theory is. And I want to cite to a really great recent article by Luis Trebek and Luz Herrera, The Emerging Legal Architecture for Social Justice, which does a really nice job of chronicling the emergence of critical legal theory in several different contexts, and particularly in the context of the Time's Up movement, the Black Lives Matter movement, and the legal movement lab or something. Louise will correct me on that one, but kind of three different contexts of where public interest lawyering has grappled with critical legal theory, critical race theory, and other manifestations of critical legal theory to kind of reflect upon itself and think about our true goals and the ways in which we are effectuating them or not. Just a couple of kind of basics of critical legal theory. The questioning of the bright line between law and politics, right? Really challenging that traditional liberal legal assumption that there was some sort of bright line. Also challenging the idea that the law is neutral, and legal pedagogy that focuses on that legal doctrine, and that doesn't expose the racist, sexist, classist tropes in legal precedent, or even the racist, classist, sexist tropes or foundations of the law itself. Also dismantling this lawyer as hero paradigm, which I just mentioned, this savior, this savior frame that does so much damage to our work and to a lot of the communities and goals that we set for ourselves. So, so the idea behind critical legal theory is to aim to transform legal practices to better serve the values of equality and social solidarity. And as I mentioned, there have been many manifestations of this represented in kind of different gender, class, race dimensions in the academy and beyond. So let's talk kind of why are we doing, one kind of foundational question for many of us as human rights clinicians is, what are we doing as human rights clinicians to address that othering, right? Because in some ways, like, othering is so fundamental to the human rights, the origins of the human rights movement, right? The idea of kind of pointing the finger at someone out there, somewhere else in the world, to identify human rights violations. And so one major challenge and project of most human rights clinicians that I know of in the US is to creatively and strategically incorporate international human rights norms into the US. Why have we done that? Well, we've got an increasingly conservative judiciary, a rollback of civil rights. This has been going on for decades now. And so the idea that international human rights principles provide a different framework obviously is quite appealing in that sense. The question, of course, is kind of how can they be effective in a country which generally rejects the domestic implementation of international human rights norms in a formal way. But many organizations, including organizations that our clinic engages with, like for example, the Coalition of Immokalee Workers, which is a local organization in Florida, has really used human rights strategies for broader activism goals, documentation, organizing, education, really initiatives that are led by clients themselves through grassroots organizations rather than lawyers. And so critical legal theory has really prompted us to question, what is the role of the lawyer in movement lawyering? What is the role of the lawyer in this broader activism? And how can we redistribute power within the relationships that we have created as lawyers and clients, or lawyers and partners? Just in terms of applying the critical legal theory doctrine to address these challenges in human rights lawyering, I've already talked about a few of these. And I know there's a lot of words on here, so I'll just kind of try to nail this down. I mean, first of all, critiquing the modern human rights discourse, right, which was limited in its focused primarily on what we call civil and political rights, the right to freedom of expression, the right to due process, maybe the right to equal protection in a quite formal sense of the word. Really leaving aside economic, social, and cultural rights, which we human rights people call ESCR, right? The idea that like the right to food or the right to housing, the right to be free from poverty, that those rights took second place to these other rights, which were the civil and political rights reified in the global north, right? So kind of imposing our own limited domestic law frames onto the international human rights frame. And also, again, as I mentioned, challenging the idea of kind of this powerless victim, and challenging ourselves to think about ways in which we could uplift individuals' voices and experiences in ways that were not that was not simply kind of the narrative, the factual narrative that was contained in your brief, or the grievance that was presented at an international human rights body. What did it mean to have a more fulsome incorporation of the voices, experiences, and perspectives and goals of human rights, of survivors of human rights violations? And a lot of that meant focusing on our own problems here at home, reframing them as human rights violations, and as I'll talk about in a moment, connecting those with transnational struggles to achieve justice in other parts of the world. So just a couple of key points for us in terms of really, we have folded a lot of this analysis into thinking about ethics and the ethical practice of law. And so in our clinic, and you'll see this in a moment, we talk about how kind of whether and how principles of legal ethics map onto our practice of law and the traditional practice of human rights law. And so we really focus on a couple of key principles, and again, kind of mapping on whether and how these are articulated in domestic ethical principles. So the principle of collaboration, the principle of network building with participant control, of ceding this control to the non-lawyer, to the local actors, having a race, gender, and class and ability lens, understanding kind of the ways in which those factors fundamentally operate in our work, and having lawyers kind of understand what adaptation means, right? That's something we all work on with our students. Okay, transnational partnerships, as I mentioned, we've really created that as a cornerstone of much of our work in our clinics, kind of thinking about helping students to think about what it means to have a transnational problem that we connect with other actors, both at the kind of supranational, right, like international levels, whether it be UN actors or international organizations, or whether we are connecting with local stakeholders, grassroots organizations, community-based organizations. The importance of teaching students that transnational networks incorporate all of that, and then really dissecting who the power players are in those relationships, how those various stakeholders come into any particular case or project, and creating this ongoing self-awareness amongst our students. And so we focus very much on building cross-cultural competencies, both as that language is used in the kind of domestic legal context and in the international context. And we really challenge students that they should not, it's a false binary to think about a concept of cross-cultural competency, for example, and domestic versus international as something that is separate and apart from one another. That's very important for students to kind of understand how the same tropes that play out in the domestic context or in the global context play out, vice versa in each other context. This is, I hope Louise doesn't mind, but I grabbed this screenshot from her and Luz's article because I think it's a really cool, visual depiction of, this is in the domestic legal context. They're primarily focusing of kind of what public interest law as a traditional kind of liberal public interest law approach versus critical law practices. And you see that from a critical law perspective, they're really highlighting that law can be just as much a part of the problem as the solution. They're highlighting different movements and places where there are joint initiatives where the lawyer is not taking center stage, where the lawyer is operating to be one tool or offer a set of tools in a larger toolbox. I'm not going to go over all of these because I think we've touched on many of them, but in our article, in the article that I co-authored, we offer 11 ethics principles, and I've expanded it to 12 here, about the importance of taking a critical legal approach to our work as human rights clinicians. Everything from having multidisciplinary approaches to our work, but also situating our work within larger movements and identifying how we can be most helpful for effectuating the goals that the individuals in those movements who come from the communities that are most deeply affected by rights violations, how we can help them to effectuate their goals, right? And this is easier said than done. And I'm going to turn it over now to Denisse to talk about how she and our students in the Human Rights Clinic are working on this project in the context of the right to food.
Thank you, Carrie. So yes, exactly as Carrie mentioned, I will be spending the next few minutes talking about the process for making project selections on the basis of the framework that Carrie just outlined. My name is Denisse Córdova Montes, as was previously mentioned. I co-teach the Human Rights Clinic together with Carrie. And I want to start by saying that I'm a fairly new clinician. I joined the Human Rights Clinic in 2019. And I came to this topic of employing a critical theory lens to my work as a clinician on the basis of my personal experience as someone who grew up in the US as an undocumented immigrant and often had to witness disempowering narratives being constructed about me and my community by people external to my experience. And this led me to embrace a critical theory lens when it comes to project selection. And so I will talk in particular about how I've implemented the guiding set of principles when selecting and carrying out one specific clinic project that I supervise. So Carrie, are you still sharing the yes? Okay, great. Okay, so this project focused on the creation of a practical guide on how to build a human right to food agenda based on recently adopted international human rights law standards. And this idea originated during a meeting that took place in the middle of 2019 in Mexico City. And here's a picture of those who came together then. It included several women who had been involved in different ways in international standard setting processes around the human right to food of rural, indigenous, and small-scale food-producing women, and included women from various continents. Some were lawyers, some were academics like myself, but most were leaders of social movements. And we met over a period of 3 days. We had been working together before, and we met over a period of 3 days with the purpose of identifying how to foster the implementation of, at various levels, of these three, in particular, instruments that had been recently adopted that were focused on the rights of rural women. So maybe the next slide, Carrie, if you can. Thank you. So throughout the course of the 3 days, but also in the months that followed, we jointly developed a methodology that attempted to create a more forward-looking, participatory, non-hierarchical tool that we called Cooking Up Political Agendas. And we attempted to use terms that would resonate with the groups that we were working with and sort of reclaim this concept of like cooking and the common cooking pot, which we use as a metaphor throughout the guide and has historical and political significance, particularly for Latin American women, where women were living under authoritarian regimes and would often come together while cooking around this like community pot and discuss politics and actions of resistance and ways to respond to severe economic and food crises. And so we were very, throughout the formulation and design of this guide, we were very intentional about the process being collaborative. Not only was it a process of a collaborative process of design, but also the guide was designed to be used collectively as well. And so maybe we go to the next slide. So we came up with a series of exercises that were meant to serve as a tool for rural women to diagnose, analyze, and come up with their own action plans for how to best use or not use the recently adopted human rights instruments that we had originally sought to try to foster the implementation of. And so the focus of this guide was on group exercises like this is one. I was trying to think of how to show you some of the exercises, but this is the best way I came up with. So they were meant to be. They were designed in a way that they could also be adopted, by different groups to address the specific needs and priorities in response to their own realities and aims. And throughout the process of crafting the guide, and maybe we can go to the next slide, we worked closely with a community, with a designer who's worked with social movements and who would attend all of our meetings. And so the tools that were ultimately created by this woman who was a designer closely followed like the essence of our discussions in a format that was meant to be accessible. We used mind maps, as you can see here, in addition to written word to express ideas. The next slide maybe shows also how we used the voice and personal stories of the rural women who were co-authors themselves and who were participating in all these meetings that we were having on a weekly basis, interspersed throughout the guide. And we also sought to present the recently adopted international human rights frameworks in a way that was critical. So this was actually the main contribution of our human rights clinic students, of like digesting and summarizing these human rights frameworks for the guide. But we really wanted women who were reading the guide to engage with these instruments in a critical way. And so we also sought to highlight and encourage the sharing, maybe we can go to the next slide, the sharing of social movement-led alternatives. And here you can see, you can't really see very well, but we asked them to reflect on like, is this framework useful or not? How is it not useful? And maybe the next slide also, we encouraged social movements we presented different alternative frameworks that were not treaties or authoritative interpretations of human rights committees developed at the global level, but were instead alternatives that social movements and women themselves had created. So again, we were trying to foster a way to critically engage with some of these instruments. And so maybe the next slide. We are now in the process of implementing this guide with various communities of women around the world. And we have actually invited anyone involved in using the guide to share the process through social media in order to foster like a transnational exchange of ideas and experiences. And this semester, actually, my clinic students and I were involved in the implementation of this guide with women in Ecuador. And we were part of online consultations that were taking place every Thursday night with women over Zoom. We were invited to participate in these consultations by a ground level organization that had been involved in the organizing work with these women for years. And we were very specifically invited as a clinic to present on the existing human rights framework. So we were careful not to diminish community power, but rather we were invited to build that power through like the presentation of some of this material. And the women themselves who were involved in these group consultations asked for this. And a human rights report will be the result of these consultations that we had throughout the semester, but the structure, the content was defined collectively. There are several women who are writing parts of it. And then maybe the final slide, and throughout the process, also women have sought to use the discussions that we engaged in to hold their own community conversations around certain rights. For example, following one consultation that we had that was focused on the human right to health, one of the women who participated organized a webinar that was focused on the recent veto of a health law that would have decriminalized abortion, and invited a doctor, a local women's rights organization representative, a local politician, and me to sort of debate the issue while she moderated. And so this project, this last example in particularly, has really enabled me to talk with my clinic students about how to measure successful human rights lawyering, and that it should not always be measured by whether a case is won or whether we get these wonderful recommendations by a human rights body in Geneva, but it should be measured by such factors as whether like the process widened the community's understanding of rights, of what's right, what's wrong, and whether it mobilizes community action. So yeah, I wanted to share that experience with all of you, and I will pass it back to Carrie, who will talk about how we've sort of implemented this critical legal theory framework in the context of our classwork.
Thanks, Denisse. That was so great. It's so inspirational to hear about what you and your students are working on in this context. And yeah, so it's really interesting, right? I've learned so much from talking to Denisse about this work, because this emphasis on process rather than kind of tangible legal outcome is really has challenged me, and I think our students and many of our colleagues to rethink success, right? And that, I feel like this is kind of critical lawyering in a whole new way that is just really remarkable and admirable. So okay, so how do we actually apply this in our class? Well, I mean, in addition, of course, to the clinical model where students are working on these ideas in their cases and projects, we also work through them in the classroom in a larger group context, encouraging students from different projects to interact and kind of share in this context. So I included 2 sample entries from our syllabi. We have a year-long clinic, and so this is a class 6, pretty early on in our fall semester, where we assigned the Makamatua article that I mentioned before. We have several recent critiques from feminists in the global South. Some of them quite punchy, basically saying, thank you, thanks to all of you in the US and the global North for trying to come help save us. Take a moment and listen to what we're saying we need. And if you could do a little more listening and a little less giving, that could be very useful for our cause. And then we assign several sections from the article that I mentioned. And then we always kind of have a set of questions for the assignment for students to grapple with. We always have one student who's assigned per class to write a response paper that gets circulated to the entire class one day in advance. And we usually give that student a chance to kick off the discussion, or we kind of critically engage with that student with the ideas that they presented. So so we ask students to kind of at this point, a very early point in their clinical experience, to talk about kind of what are the cultural barriers that they identify, how, given the limited experience you have with your own clinic project, do you think that some of these ideas overlay with the work you have before you? And so, okay, so that's kind of early on. And then skipping ahead to, in this case, it was towards the end of the second semester, we give them a simulation, and that's the simulation that we're all going to grapple with together for almost the remainder of this webinar. And so in addition to asking them to kind of go back to the readings from several months before, we asked them, as I mentioned before, to look at several ethical rules, right? And questions about kind of competence and scope of representation, diligence, communication, confidentiality. What is the unauthorized practice of law? And choice of law questions, right? And I mean, from a human rights perspective, you look at these the codes from the model rules of professional conduct or the state specific rules, and they just seem so inadequate to address the complexities of modern day lawyering, whether it's in the international human rights context or in our, in many of your domestic poverty clinics or cause lawyering clinics. These rules just seem so inadequate to address, the very complex multidisciplinary, multifactorial lawyering and movement lawyering that we're really, pushing for in much of our work. Okay, so with that, we are going to share, Denisse, I don't know, could you share the actual simulation with the group? I think there's like that attachment feature in the chat where you can attach the document. So while Denisse is getting that started, I am going to try to actually, these are the questions that we're going to give you for your breakout rooms, but I'm going to try to stop I'm going to stop the share for just 1 minute. And actually, while I'm pulling this up, just to invite any questions or conversation. Great. Okay, so let me just.
Actually, I can't seem to fully figure it out. Maybe, Allison, should I email it to you or do I have that capability to share a file?
I think I may, yes. If you send it to me, then I can try and get it to everybody.
I also wanted to mention that it looked like Louise had her hand up.
Yes, Louise.
Just be sure to unmute yourself.
I just wanted to say, if I didn't have a chance to say, I'm thrilled with the fact that you're doing this and using our work, which we just wrote, looking ahead. And I just a couple of comments. I think it's very important that you're building on the Human Rights International, integrating it into the U.S. Beth Lyon wrote a paper years ago that was published in our in the book we did on global public interest law, and that was like 2005, and she was one of the first people to discuss that. And I think it's wonderful the way it's become just integrated into this, and I think it's great. And Luz and I are thinking about doing a webinar on going over and including more people, including the people who are now reinvigorating and looking at critical race theory from the doctrinal point of view. So I think it's great if we can have so many clinicians who are working on this, and that they can be integrated with other disciplines, but also with the people who teach critical theory in the traditional curriculum, because that separation between clinicians and people who teach in the regular has always been a very unpleasant and unfortunate development. So I hope that we can move on and try to do some of that in the future. So I intend to try to stay involved with this effort. I think it's great.
Great. Thank you. Yes, and Beth Lyon has done some really important work for anybody who's interested in this. She's a must read. So while we're trying to figure out if we can attach the file, I'm going to just share my screen. So do you all see this simulation? Okay. So I'm going to read through the simulation, and then we're going to break up into groups and talk about it. There are 3 phases to the simulation, and we're going to focus on phase 2 because I think that's the most interesting for us as clinicians thinking about critical theory. Okay, so we give this to the students in advance, and then we ask them to kind of work it in advance, and then come to the Zoom, from the Zoom breakout room back to the group to discuss. So this is based on the Dominican Republic and Haiti, and litigation that I've been involved with over the past 2 decades, actually since I was a 1L in law school with my own human rights clinic. And we changed the names of the countries and the island. I'm not sure whether that was a good choice or not, but the island of Equatoria is supposed to be the island of Hispaniola, and Alcalonia and Occidenta are the 2 countries that share this island. Alcalonia is the equivalent of Haiti, has suffered from war and instability for years, while Occidenta has been relatively stable. As a result, many migrants travel from Alcalonia to Occidenta to work and live. And generally, Occidentals are lighter skinned, speak a different language than Alcalonians, though hundreds of years of migration have resulted in many darker skinned Occidentals who have no connection to Alcalonia. As a poor country, Occidenta has had difficulty shouldering the burden of Alcalonian migrants. And in addition, there's a long history of discrimination in Occidenta, which has only gotten worse with the increasing migration. So there's, as with any migration situation, there's an issue of the regulation of migration because of porous borders and unscrupulous business people who profit from the cheaper labor of illegal immigrants. And the government regularly expels dark-skinned people who don't have papers or who speak with an Alcalonian accent. Sometimes they expel them in mass expulsions. There are reports that many of those expelled were legitimately living in Occidenta, either because they were born there or because they were legal permanent residents, but their official papers were destroyed. So you are a participant in the Human Rights Clinic, and we've been working with an NGO in Occidenta called Occidental Rights to explore collaboration. That's the leading organization fighting against discrimination of people of Alcalonian origin or descent in Occidenta. And the NGO, Occidental Rights, has requested the clinic to assist them in bringing a case before the Inter-American Commission on Human Rights. And they offer that they're going to facilitate a lot of the groundwork. They'll find the victims, they'll collect the documentation, do the translation, they'll arrange the logistics, including interviews with the clinic lawyers and law students. But for political reasons, they're concerned about being named in the case. The government has retaliated against them, called them foreign spies, tried to revoke their NGO status they're in the domestic context, and they fear kind of that being having a higher profile in the case could just result in bad things for them as an NGO. So they've identified a group of victims who were deported to Alcalonia in mass expulsions. Some claim to be legal residents or citizens of Occidenta. All claim that they experienced rights violations through the mass expulsions, and they would request both financial damages, also regularization of their documentation, and a larger order to the country to cease further mass expulsions. So the first phase of this simulation really prompts, and I'll just highlight this is not the focus of our conversation right now, but this really prompts students to think about a lot of the traditional lawyering questions that they would need to think through, kind of, have there been rights violations? And if so, like, how would you go about documenting them and chronicling them? And what would you need to do? How would you structure your petition? Would you have multiple petitions or one petition? What's the relationship with Occidental rights? And do you have any concerns? And so we kind of preface the next phase of the case about what are any concerns that you have? What do you need to know to move on? And what's the goal from your perspective? And it's interesting. I mean, there's a lot we can say about this phase, but a lot of students immediately have suspicion of Occidental rights. A lot of our students kind of say that that the group, if the group isn't willing to kind of be the public face of this lawsuit on the ground in Occidenta, then maybe they can't be trusted, right? And so we talk through in that context kind of the particular the dilemmas for NGOs around the world, including in the United States, of having a high profile in contentious political matters, and work through that with the students. And then in terms of the goals, this gets to Denisse's point that she just made about kind of what is the goal, right? I mean, the Occidental Rights has articulated a goal of wanting to go and get a ruling from an international human rights body. But what does that actually mean, in the larger context, right? How will that help to solve the problem? And so we ask the students to think through that. So I want to focus on phase 2 here, and it's I want to kind of just try to summarize it so that we can get into our breakout groups. But here we say that the clinic sends a team in October of 2009, and the organization, the local NGO Occidental Rights, organizes the visit. You travel together. And everybody agrees that we're going to file a petition with these 18 named victims, and we're not going to name Occidental Rights. There's a lot of kind of international applause over the submission of this case. It's standing up for the right cause. It's a landmark case. And then 2 years pass, and now the clinic has a situation where they're achieving progress in their legal goals. They have an international court ruling against Occidenta in a separate case that is related about discrimination against people of Alcolonian descent. But this has resulted in a big backlash in the country. This isn't familiar at all for us, right? I mean, xenophobic, nationalistic rhetoric that then gives rise to a new political regime. And the government is actually saying, if the international human rights community continues to barrage them with scrutiny and accusations of rights violations, that they're going to withdraw from international human rights treaties. And so, what to do, right? You consult with an NGO, an international NGO who has long experience at the commission. They say that you have to do backroom advocacy, encouraging the commission to take up the case. They say, you might want to just withdraw the case discreetly. This is going to lead to a lot of domestic tensions, and that even if you get a positive decision, the country may not respect the judgment at all. At the same time, like, the local NGO really wants this. They want to vindicate the rights of the people, and they feel like of the people they represent, and they feel like they've hit a brick wall. So we asked the students, how would you go about coming to the decision about whether or not to go forward? Who would you consult with? What factors would you need to consider in making your decision? And how would you justify that? And don't worry about this last paragraph. So I guess we're interested in breaking up into groups right now to discuss these questions, but also the larger questions that I just mentioned, which I'll go back to, which involve kind of, how would you use this simulation in your own clinical teaching? And, particularly for those of you who are not human rights clinicians, like, does this resonate for you in your own teaching? And if so, how might it be adapted? How would you present it or teach it? And any adjustments or critiques or edits that you would suggest for us as we continue to teach from this. So yeah. So Allison, should we break up into groups then? Okay.
Yeah, I'm going to do just a few minutes, so then we can wrap up for just a minute when we get back. Does that sound good? Okay, and we've lost some participants, so I'm going to do a few here. All right.
Allison, I'm not going to join since I don't teach.
Yeah, that's fine. Mhm.
Hi, sorry, I was placed in the same room as Carrie, so I was going
Oh,
to try
gotcha.
the one. And I guess we should just do a few minutes, right?
Yeah, so I can move you to room 2. There are just 2 rooms now because folks haven't been.
What happens? Or I could stay with you. Whichever one.
Yeah, are we? It looks like I'm trying to move you to room.
Hi, Denise. Sorry I came late. We had the clinical faculty meeting that ran over, but I wanted to at least catch some part of your session.
Right, Tamar. Thanks for joining. I think a lot of people leave when we have breakout rooms.
Oh,
So, yeah, oh, I see it. I see it. I can join breakout room too.
Oh,
Alice,
terrific. Okay.
Okay. if you want to join our breakout room tomorrow, feel free.
I feel like I just came, so I'll wait for when you resume.
Okay. See you soon.
See you soon. Thank you.
Tomorrow I can put you in the same room as Denisse if you'd like.
It's fine. It's fine. Thank you, though. That's very
I think
nice.
they're just going to take like 3 more minutes and then we'll close out.
Great. Great.
Cool.
This was great, ladies. I'm sorry I've been super distracted and I have to go for real now, but thanks for doing it.
Thanks for joining us, Jill.
Yeah.
Best wishes for the rest of the semester.
Yeah, for sure. Right back at you.
Thank you. Take good care.
Yep, you too.
Right, I'm closing all rooms. I think some people will come back and some probably won't.
Yeah.
Here we are.
Here we are, and I know we're at time.
Well, thank you so much to Carrie and Denisse for your amazing presentation. So inspiring to see all of the ways in which you have applied critical lenses in your own clinical teaching and your clinic work. I had several private requests in the chat for to share slides. So if you all are comfortable with that, would love to make those available to our participants today. And once again, encourage you all to keep up with the listservs in the CLEA website. We do have more presentations planned for spring 2021. And best wishes to you all for wrapping up the semester and having a safe and happy winter break.
Thank you so much.
Take
Thank
care.
you so much.
Bye-bye.
Thank
Bye.
you.